Yuval later. So thank you very much, Professor Alovich. It's really what we were asking to add to this session. So thank you very much. And this actually concludes our first session. And for our second session, I would like to invite my colleague Professor Michael Birenak, who is the Associate Dean for Research at Tel Aviv University Faculty of Law. He is the Director of the Horowitz Institute for IP and the Director of the Parasol Foundation Trust International LM Program. Please.
Thank you. Thank you, Yaniv, and Jennifer, Laura, Tal, Jacob, can you please come down here? It will be easier for us to facilitate the discussion as we proceed. Okay, we started late, but we will try and manage with the time that we have. Some 20 years ago, in the mid-90s, as the internet became more popular, one of the slogans that we often heard was that information wants to be free. Remember those days? They're long gone. 20 years later, with situations such as what we've just seen from Yuval, information maybe wants to be free, but it wants also to be controlled. And those who want to control the information, sometimes they are the bad guys, the hackers, sometimes they are the governments, and sometimes it's just us who wish to control our own personal information. So there's a struggle between freedom and control in the digital environment. Security, cybersecurity, obviously, is crucial, as we've seen in this talk, and as all of us, I'm pretty sure, have followed the news over the last 24 hours. Cybersecurity is, of course, crucial. However, security and cyber and technology is not only a technological environment, it's a human environment. And in this human environment, there are not only the technologies, there are also other things. These are the things that we lawyers call human rights, especially privacy and freedom of expression or free speech, as we call it. So this session will try and focus on the interface between security needs in the digital environment and human rights, especially privacy and freedom of speech, which these two also are interrelated. For this purpose, we have 4 experts and excellent speakers from the US, from the UK, and from Israel, and it's a great pleasure to have them here. We will go according to the following order. We will begin with Jennifer Daskal, then move to Laura Denardis, to Jacob Rowbottom, and Tal Jarsky. I will present each very briefly in due course, as you can easily Google them and see their extended bios. So our first speaker is Professor Jennifer Daskal. Jennifer is an Associate Professor of Law at American University, Washington College of Law, where she teaches and writes in the fields of criminal, national security, and constitutional law. In one of her previous stages before the academia, Jennifer was counsel to the Assistant Attorney General for National Security at the Department of Justice in the US, so she has also not only the academic perspective, but also the governmental perspective. So Jennifer, please. Thank you.
Good morning. I am delighted to be here. It's an honor to be at this really terrific conference, and it's been a great few days. So my article is part of a broader project looking at territoriality and data and the ways in which data, an inherently unterritorial medium, is being regulated by territorial-based states, the many challenges this poses, and the implications for privacy, security, speech rights, sovereignty, and democracy. I first got interested in this issue several years ago when I learned about what is known in the United States as the Microsoft Ireland case. This case began back in December of 2013, and it may very soon make its way up to the U.S. Supreme Court. In this case, the U.S. government sought to compel Microsoft via a warrant issued by a judge based on a finding of probable cause to turn over emails associated with a particular account in a law enforcement investigation. Microsoft refused, saying that the data was stored in Ireland and that therefore this was an impermissible extraterritorial exercise of its warrant authority, that the warrant authority only extended to data within the United States. The government said, no way, you guys are based in Redmond, Washington. You can access it from Redmond, Washington. What matters is where you are, not the data is, and this is clearly, therefore, a territorial, not an extraterritorial search. So the magistrate judge and the lowest court all sided with the government, but when it made its way up to the appellate level, to the Second Circuit reversed and sided with Microsoft. And the result in the United States, at least in the Second Circuit, is that the U.S. warrant authority only reaches stored communication data that happens to be stored within the territorial boundaries of the United States. Now, this is causing huge problems for law enforcement. Law enforcement's investigating a local crime, local victim, local perpetrator. The data or some parts of the data happen to be stored abroad. The U.S. government can't access it in some cases. It has negative consequences, in my view, for privacy. In this case, the government proceeded based on a warrant issued by a judge based on a finding of probable cause. And importantly, it reflects a total mismatch between the rule that was adopted in this case and the sovereign interest that the presumption against extraterritoriality that was applied in this case is meant to protect. And it stems from what I see as kind of a blithe transmission of rules governing other forms of tangible and intangible property to the regulation of data. There have been 5 magistrate judges. These are the judges who look at the search warrants when they're first requested by the government, who have ruled the other way precisely because some of these concerns. And I'll talk more about this in a minute, but I use it now, this case now, as an example to highlight the ways in which data is requiring us to re-examine, rethink, reevaluate what is territorial, what is extraterritorial, and the underpinnings of those assumptions. And I want to make 4 broad claims. First, data is different in key ways from other forms of tangible and intangible property, and these differences matter to our understanding of what is territorial, what is extraterritorial, and thus the enforcement, prescriptive, and adjudicative jurisdictional rules that do and should apply. And simply looking at the jurisdictional rules that have been applied to other forms of property ultimately don't work and undermine some of the key normative values that these rules are meant to protect. Second, and I want to be clear about this is not the same as saying that territorial-based rules do not matter. They do. There was a long-standing debate in the 1990s amongst academics between unterritorialist people scholars like David Post, who argued that data, because of its unique properties, would defy national regulation and lead organically to the creation of kind of supranational global structures to govern the new internet. That obviously has not come to pass. On the other hand, there were the territorialists, scholars like Jack Goldsmith and Tim Wu, who insisted that territorial-based sovereigns would find ways to assert territorial-based controls. And they obviously are right. That said, and this takes me to my third point, the interconnectedness of data means that there is, as a result, a new form of international rulemaking via territorial-based regulation. So to the extent that we remain an interconnected internet, which I hope we will retain rather than retreating into our silos, territorial-based regulations can and do have broad extraterritorial effect, and those extraterritorial effects need to be mediated and moderated. And fourth, and finally, this is my other key point, these cross-border effects are increasingly being regulated and controlled and mediated not by governments, but by the private multinational big corporations that manage our data across international borders and therefore help get to determine which rules apply, how they are interpreted, how conflicts across borders are being mediated. So with the remainder of my time, I will explore how these themes are being played out briefly, with a return to a discussion of law enforcement access to data across borders, questions about content controls, and finally to discuss a little bit more about the role of the private sector in all of this. So the issue of law enforcement access to data across borders is an increasingly important topic. It's a topic of conversation not just with respect to the one U.S. case that I talked about. It's actively being debated and discussed in the Council of Europe. It's a topic of a recent year-long study that was just released by the European Commission, and it's obviously a topic on the agenda in many other places as well. And just briefly, the problem arises when law enforcement investigating a crime in state A involving local victims, local perpetrators, local witnesses, discovers that either the data or the provider that controls the data or both happen to be across an international border. This is an increasingly common phenomenon, and it's also relatively new, deriving from the growth of the cloud, the development of the cloud. The background rule, the rule that previously applied and the one that was relied on by the Second Circuit in the Microsoft case, is that under international law, state A cannot unilaterally engage, cannot unilaterally send its law enforcement officials into state B without state B's consent. So a US FBI agent cannot unilaterally cross into Israel and seize data out of the home of somebody in Tel Aviv. Doing so would be a clear violation of Israel's sovereignty and a violation of international law. Instead, the US would need to make a request to Israeli authorities, and Israeli authorities would, to the extent that they agreed, conduct the search according to Israeli law and then ultimately send the information back to the United States. But there are good reasons, I think, why the rules governing transmission of data across borders ought to be different than the rules governing traditional searches and seizures of physical property. First, there's no agents that are crossing borders in the examples that I'm talking about. And data, as we know, is highly mobile, it's highly divisible, and it's a highly unstable basis for delimiting jurisdiction. It's often held in places that are totally disconnected from the data user or any other relevant factor other than the decision of a third-party provider to place a server in a particular location for reasons like efficiency and other economic reasons like tax rates and energy costs. Meaning that there's often no normative link between where data happens to be held and the other legitimate sovereign interests in either accessing data or controlling its access. The divisibility also means that when either a provider copies data and provides it to law enforcement agents or the government does so itself, that the requesting agency is not in any way depriving the host state, the state where the data is located, from being able to access it. This is obviously different than the example where US FBI agents go into a home in Tel Aviv and spirit out the only diary, the only photo book, the only piece of property. Then you've deprived the host state of the ability to access it. Not true with data because it can be copied without altering it. So therefore, this raises, I think, important questions about what are the appropriate jurisdictional hooks that ought to apply, and I would say that location of data is probably the worst. It has really negative security costs. It's bad for efficiency. It encourages data localization, mandatory data localization rules as a way of controlling, of ensuring access to data in ways that have big efficiency costs and price small startups out of the market. In the US context, I would argue that it's bad for privacy in the sense that instead of the US government getting a warrant based on probable cause, the rule effectively requires them to go increasingly to foreign governments and ask for their assistance. In many cases, the privacy rules of the foreign government are less protective than the requirement of a warrant based on probable cause. On the other hand, the idea that states can simply access anything anywhere is also concerning. This was an approach that was adopted by the Belgium courts in 2 cases, where the courts have basically said that as long as data is received in Belgium, it's a territorial search, even if both the provider and the data are outside of Belgium. So basically, it makes every single request for data territorial because it will ultimately be received in the jurisdiction that requests it. And this, too, is concerning. It obviously serves the security, the law enforcement interests of the Belgian government, but it creates, I think, a concerning precedent via which states could unilaterally reach across borders anytime they so chose in order to access data without regard to anything like baseline privacy rights, baseline concerns about due process. And it also fails to respect what I do think is the legitimate interest in sovereigns in controlling access to people's data, to the people within their country, controlling not the data in their country, but having controls over the individuals within their country and potentially setting limits about when foreign governments can access the data of those individuals rather than the zeros and ones themselves. As a practical matter, this kind of rule also runs headlong into conflicting blocking provisions that are imposed by a number of states that prohibit disclosure to foreign governments and therefore puts big companies in the middle of these 2 competing obligations. So I'd argue that we need a new solution that mediates between these 2 extremes, that takes into account the various interests at stake, which I will quickly posit here involve at least the following: the sovereign interest in security, which translates into the ability to access data relevant to investigation of serious crime, regardless of the location of the data; the sovereign interest in controlling, setting the rules for one's own citizens and residents' data, and potentially setting limits on the ability of foreign actors to access that data; the interests in privacy protections and promoting due process, human rights, and the rule of law, both as a normative value and also from a more self-interested sovereign perspective because of the fact that all of our data is so intermingled that the rules matter even if one's only interest is to protect one's own citizens and residents, and mechanisms for accountability and some sort of transparency. I have a lot more to say about this. I have a lot more to say in general about all these topics. I am running out of time, so I will just skip the discussion about content regulation and just mention briefly what I spoke about at the beginning, which is the rising importance of private actors in this space. The companies, the major multi-corporations that manage our data across borders are making critical decisions about a whole range of rights and security, speech rights, privacy rights, decisions about what information governments are able to access from a range of kind of minute business decisions about where to place servers, to bigger decisions about how they are organized, where they place their law enforcement personnel, when to comply with and when to resist governmental demands for information. And I think this means that one of the most important players in determining the scope of individual privacy rights and determining the scope of speech rights is no longer just governments, but increasingly these private companies that act as intermediaries between the citizenry and governments, and not just one's own governments, but really governments across the globe. I think it's a power that's likely to grow, not diminish over time as our lives become even more digitalized. And this is going to require, I think, some hard thinking about accountability, about responsibility, and about the rules that ought to apply. So I will stop there.
Thank you.